Hello, my name is Phyllis Rumwin. I'm a partner with Geomonco Law Partners, and I'm here today to talk to you about the steps you need to take to file a small claims case. Now, in general, a lot of people try to file these cases on their own, and while it is possible, I always encourage people to at least call an attorney to get some advice about your area and your claim that you are trying to file. So when you are trying to file a small claims case, the first thing you need to do is draft your complaint. Your complaint is essentially the document where you tell the defendant, the person you are trying to sue, or the company you are trying to sue, what you believe they did wrong. This informs them as to what they're going to be responding to and lets the judge know the issues to be determined in the case. The next thing you have to do, once you have filed the complaint, is serve the other party. If you do not get service on the other party, if you do not hand them a copy of the complaint through a sheriff or hand it through a special process server and do it according to the laws, then you cannot get a judgment against them. If they don't know about the lawsuit, then they are not responsible for it, even if you have a valid claim. Now, once the complaint has been filed and the summons has been served upon all of the defendants, then you will go in front of the judge and you will likely set a trial date. Small claims cases do not have discovery except in unusual circumstances. It's a condensed process. It's for cases under $10,000, and they are trying to keep the process itself inexpensive, given that the amount of damages are below $10,000. So when you go in front of the judge, you will then set likely a bench trial date. Once that date is set, then you need to get all of your proofs ready. Witnesses, documents, photos, anything you need to prove your case needs to be ready for the date of trial. If it is not, it is your burden, and if you do not have it ready, the judge will likely deny your complaint and find against you. If the defendant does not appear on that first court date, you may be able to get a default judgment. Essentially, you won't have to go to trial. You can get a judgment against the defendant for failure to be there on the basis of your complaint, and all you have to do is prove your damages. Prove the amount that you are claiming you have been wronged. Once you do that, then you can immediately go into post-judgment proceedings. You don't have to proceed to trial. That can happen often, but if not, then that's fine. You have the reason you filed is because you believe you have a strong case, and you need to set it for trial and prove your case at trial. Once you have gone to trial, assuming that you win and you had a strong case, then you will now have a judgment. In Illinois, you now are earning 9% interest per year on that judgment per statute. That does not mean that you will automatically get paid. A lot of times when a client calls me, I inform them, look, you have a wonderful case, you are very likely to win, but even with a judgment, you are not going to get paid because the defendant can't pay for whatever reason. Either they have no liquid assets, or they are out of state and you're going to have to get some sort of judgment registered in another state and try to get their assets that way. A lot of times, once you have the judgment, it's even harder to get paid. There are actions that you can take. You can try to freeze bank accounts. You can attempt to garnish wages. You can do a citation to discover assets. There are many options that an attorney could help you with post-judgment. But I often tell clients, be sure if you're going to file the small claims case that you know you are likely to get paid on that small claims case. If you do not believe that the defendant or defendants can pay you the money, you don't think they have the funds even if you were to win, you may want to consider not wasting your time and effort in filing the small claims case, even if you have a valid complaint. A lot of times an attorney can help you to make that analysis, to determine whether or not it makes sense to file a small claims case. If it makes sense to go after the defendants for what they, for either breach of contract or a failure to do work on your house appropriately, whatever it happens to be. If you would like to proceed forward and you're not sure if it makes sense, I encourage you to call an attorney. Many attorneys do free consults, and they can at least give you an initial analysis. Our firm does it at Geomanco Law Partners. You can call any of the attorneys here or myself, and I'm happy to walk you through the process and give you an analysis of your case. If you want to do that, you can call us at 630-635-5555 or visit our website at glawpartners.com. Additionally, a lot of attorneys will do small claims cases on a flat fee basis, which means that you know that you're not going to spend tens of thousands of dollars on a case that is worth less than $10,000. That's something that you should also ask the attorney or my office regarding any employment or hiring that you do for that attorney. Please feel free to give us a call if you have any questions. I'm always happy to walk through a client's case with them. And as always, good luck out there.